Good morning. What is up? Excited to be here. It's bright and early. Big day today. We are excited. Hopefully, this is going to go as planned. Supreme Court does a web stream. We're going to be trying to catch their stream. We hope it's going to work out. It should. We'll see, though. You never know in this crazy world. So without further ado, we don't have any time to waste because this thing starts promptly in 20 minutes, and I got to get my brilliant co-host and the most lawyerly person I know, Allison Ma, to the stage. What's up, woman?
Hey, how's this microphone working?
It sounds great.
Okay, because I can't tell which one's on. And
I can hear you. Hopefully everybody else can hear you. Can you guys hear Allie out there? Let us know. All right, so let's jump right into this. We have zero time to waste. So what's going on today is both Adnan Syed and Young Lee are making their oral arguments to the Supreme Court of Maryland, not the Supreme Court of the United States. I'm assuming that all of you guys in the stream have an idea of what Syed is. I don't have time to go through the background of the case. And frankly, what we're going through today in the courts has very little to do with the underlying case, and it has everything to do with what happened more recently. And Allison, I assume a majority of the people here have not ever watched a Supreme Court argument or an appellate court argument. Can you tell them what they can expect today?
Well, as far as the Maryland courts are concerned, for the Supreme Court, each side gets 30 minutes of argument. And I'll give you some more of the technical stuff, but why don't you tell the people, is this the type of argument that they're used to seeing in a court when they hear closing arguments? Or
no, it's not. So if you're used to watching trials, which most of us are, this is vastly different. This is nothing that you're going to see ever in a court of law, because you're talking about a panel of judges that are going to be sitting there, the Supreme Court justices of the Supreme Court of Maryland, and you're going to have them all sitting there, and you're going to have the two lawyers, and they're focusing on 5 issues, which we're going to talk about what they are. And once the lawyers start talking, this isn't just like they're going to be sitting there speaking for 15 minutes. This is a very back and forth type situation. Remember, all of these justices have read these massive appellate briefs that have been filed. And Allison, like you said, that some of them were over 200 pages long.
Well, I mean, some were like with exhibits, but they're all, very, very substantial.
Right. So,
and there are amicus briefs, which I know we don't have time to even get into, but that just means that like an interested party, such as the, National Criminal Defense Association of Lawyers. Sorry, we're rushing and I'm already stumbling over my words, can put a brief in with like their position for the courts to consider, although they won't be there for oral argument.
Okay, right. So just I don't want people to get the impression that the judges are being rude, because if you're watching it for the first time, it's a time thing for them. Remember, they are on a timed clock. You will see the clock in front of the lawyer so they know what time they have. And they've got 5 issues, big issues that all have to be argued in a very short amount of time. Were you going to say something? I saw you get ready.
No, I just wanted, because I feel like you were going to jump to the issue. So I wanted to get through the technical stuff first. So they've got 30 minutes for each side. Now, this is where it gets a little tricky because the appellant can reserve a portion for rebuttal. But here you've got two different parties with cross appeals. So we're not sure exactly how they'll handle it. But whoever starts with like their opening argument, meaning, you know, if the justices really let them get that far, they can't raise, like, save an article in reserve, an issue in reserve, and then raise it, you know, in rebuttal. But as Bob sort of mentioned, they're going to be coming at them with questions. So I don't think it's going to
fast and furious. Like they come at that. That's what I'm trying to say. Like, I don't want people getting the impression that the judges are being rude when they interrupt the attorneys in the middle of them speaking, because everybody's pressed for time. And these justices, as I've said, they've reviewed the briefs. They have their questions that they want answered by the lawyers. If they just wanted the argument, they could just read the briefs. They want to have the attorneys answer the questions that they have formed coming into this hearing. So that is going to be the point of it. It is going to be very back and forth. I saw somebody say they're asking questions. That's what that means. Yes. All the justices, they'll just jump in when one has a question, and they come.
Want to play it. Sorry.
It's the type of hearing that I think it's going to be fast and furious.
Right. And I was just going to say, you want to pay attention to those questions, because that's where you're going to get the mindset of that specific justice, what they think is important, what they are focusing on, or sometimes something they want to get across to the other justices. So once in a while, sort of like if you're watching Congress, they're asking a question just for the other people to hear the way they're formatting it. But in any event, so because here there are, you know, two appeals going, the court says that they will either decide who goes first, or it's going to be in the order, the appellate first in order on the docket will open and close. So in this case, I'm assuming they're going by the Supreme Court docket. It would be Syed. He filed his appeal first. If they're going overall by the appellate docket itself, which wouldn't make sense, so I'm assuming it's the Supreme Court docket, but they could go the other way. Only two lawyers can talk at a time, for each side. And if there's more than one lawyer, they can sort of split that time up as they want. The justices can, you know, decide they want to give someone more time. But if the lawyers wanted more time, they had to ask for it 10 days in advance. I haven't seen anything. 10 days after filing the appellate brief, and I didn't see anything like that.
Okay. And just so the people understand, as far as that time constraint they have, they can break it up. So say, for instance, you have Syed's attorney up there and he's like, all right, I'm going to do 20 minutes now and I'm going to reserve 20 minutes for rebuttal. Can they do that?
10. You mean 10?
Yeah, right. Whatever adds up to 30 minutes.
Whoever is considered to be the movement can. So I don't know how the court's going to handle that. Because
but aren't they both considered to be the movement? Because they both.
That's what I just read. That's the rule that I just read to you. That when there is two of them, they are the court can either decide how it's going to go, or it defaults to the first in order on the docket will open and close. So they would get the rebuttal time.
All right. So that, it's pretty.
So we got 10 minutes. Do you want to read them the 5 issues that's right from the Supreme Court's website?
Yes. Okay. So this is directly from the website from the Supreme Court of Maryland. Okay. There's 5 issues. Remember, they are not going over the facts of the case in terms of the history of the case. They're going over these issues and these issues only. So the first issue is falls under the category of criminal procedure, and it's, does a lawfully entered nolli prosequi render moot an appeal alleging procedural violations at a hearing occurring prior to the nolli prosequi? Allison, you want to try to translate that for the people?
Yes, as quickly as I can. So what they're saying is that when something's moot, it's like there's no issue or controversy for the court to consider anymore. So what Syed's position was the state has now basically the state has dismissed the case. There is nothing left for you guys to hear. this issue that they wanted to raise is irrelevant now because the case has been dismissed. Mr. Lee, in turn, argued that they should have not been able to file the nollie pros because their appeal to the appellate court was pending. And the appellate court decided that the nollie pros was void. And they found under the law it had to be void in order for them to say that it's a nullity and to go backwards. So that, I think, will be an issue that the Supreme Court is looking at, because they have to look at how something like that affects other law in place. And we have a long history of law about either judgments or orders that are like void from its onset. And they take that language very seriously to find that, as opposed to saying, well, we're going to reopen proofs and let this guy come in and, you know, and make a statement or something like that. So I hope that was enough, because we've got time.
Yeah, I mean, we're pressed for time, and obviously after this is done, you know, that's what this is going to be for. We're going to, like, you guys hopefully will have questions, and we're going to hang around and try to answer them for you. All right. So the second issue that they'll be addressing is, does a victim's representative, which is young Lee in this case, a non-party to the case, meaning he wasn't the defendant and he wasn't the state, okay, have a right to attend a vacator hearing in person, or does remote attendance satisfy the right? So this is a very current day Zoom question. Does that suffice in lieu of him being in the courtroom?
So first of all, the victims advocates and victim representatives and the victims, they do have the right to be told about hearings. They have the right to attend hearings, and a vacator hearing is one where they have the right to attend if they want to. So that's another issue that they're saying, well, you know, this is something that the Supreme Court in Maryland has recently adopted new rules, even post-COVID, that say the court in its discretion can mandate that somebody appear remotely. So, you know, that's also going to be an interesting issue, because sometimes it's easiest for the court to answer an issue on like something very simple.
Right.
And I think it is sufficient personally.
I do too. And I mean, it's modern day. Like in his attorneys, and I'm going to keep this brief, we love Zoom. Like, if it's not a hearing where we want to be able to look a witness in the face and it's a status hearing, Zoom is fine. I mean, it's essentially the same thing as being there. All right. Issue 3, was notice to the victim's representative of the vacator hearing sufficient where the state complied with all statutory and rules-based notice requirements?
I feel like here the court's going to say, look, you know, the heart of the notice, I'm not sure that you did here, because what they're saying is the rule only says they have to get notice. They have to be given, you know, information about when hearings are. And here they did give them notice at the very end of the day on Friday about something on Monday. And part of what Lee's arguing is they didn't even tell me I had the right to come in person. They just gave me a Zoom link.
Right.
Sorry, go on next.
No. I'm sorry. The justices are getting ready to come out. We got the clerks. I'm going to wait till the judge. So we got to go quick on the last two. Must a victim's representative seeking reversal show prejudice on appeal?
That's the next one? I thought that was the last one. That's
4.
Okay, that to me is the hugest issue. There's something called harmless error. If the victim's representative doesn't even have the right to speak, there can be no error here. Plus, he did get the ability to speak. However, if they say he does have the right to speak, you've got this issue where he's saying, I was flustered, I didn't have a minute's time, you know, but either way, they need to show that he could have done or said something that would have changed things. And that's going to be very interesting, because it's the same for a defendant. A defendant has to show something wasn't harmless. I was prejudiced. This would have changed the outcome. This would have made a difference. They're going to have to find here. This is what I think is one of the strongest arguments, that there was prejudice. Now, if they find that he had the right to participate, then they cannot find, I don't think that it was sufficient. But here, I don't think there's any chance that the court's going to find he had a right to like actually participate and challenge the evidence and put on his own case in that sense.
Okay. All right. And what I think is probably the biggest issue, aside from the first issue, is issue 5, is a victim's right to speak incorporated into the vacator statute of Maryland, which is code section 8-301.1 of the criminal procedure article, where no party or entity other than the victim has an interest in challenging the evidence alleged to support the vacator. Explain that, because it's a big one.
Okay, so first of all, I don't think the Supreme Court is going to recognize a new rule, an implied or inferred rule that only applies in a very small set of circumstances. It's not what they do. They interpret the statutes, and here there are statutes that say when someone has the right to speak and when someone has the right to attend. So I do not think, especially the way that they're putting it, like that they're allowed to review the evidence and like put on witnesses, not a chance in hell as far as I'm concerned. There is this issue that the appellate court said, so they make reference at the end of the vacator statute to the sentencing statute where the victim's advocate or representative or victim has a right to speak. And Mr. Lee's lawyer argued that was basically the court adopting this section and saying he also has the right to speak here. I've never seen it where they're like, I'm going to be vague and then do a cross-reference. The appellate court said, no, that cross-reference was sort of to say, here he has the right to attend, whereas in a sentencing hearing, he has the right to speak.
Right. Okay. And this goes beyond that, though. So, because like when we're talking about a victim or a victim's rep speaking, it's typically what we're used to seeing, which is like a victim impact statement. That's right. Where you'll see family members getting up there and raging against the perpetrator and saying you've ruined our lives and we're glad you're burning in hell and all that kind of stuff. What they're talking about here, and I agree completely, Allison, that they are not going to be making new law here in terms of the statute and adding to it, because they're essentially saying, does the victim have the ability to be able to address the evidence, which is crazy.
Like put on their own witnesses.
But attacking the evidence in the underlying trial, it's like they're a non-party. Yes, obviously it's really about them. But in terms of, at the end of the day, this is between a defendant and the state, and the victim can't come in and start putting on its own evidence and saying, well, we think this evidence supports the conviction. So, all right.
You can imagine in like a post-conviction hearing or something like that, where sometimes the victim, I've had cases where the victim does not think this is the right defendant. Right. They're not opening the door to let people come in and be like, put on evidence of a third party or, undermine the prosecution.
Yeah.
And they're surely not making a loophole for when people are on the same side. That's...
All right, we just hit 9 o'clock, 10 o'clock Eastern. I anticipate these doors and the 7
You can stick the screen up in the background, no?
Yeah, let me see if I can get it in.
So people know they're not missing anything. You guys might lose me for a minute. I might pop out. It's because I'm on Zoom Court, but I'll be right back.
All right, and you guys, I'm going to mute both Allison and I. She'll give me a hand.
All right. Hi, everybody.
All right. So
I hope you guys found that interesting. I mean, to me, it was very interesting, but I'm a lawyer.
Yeah, we're law nerds. So, all right, here's what we need to do, Allie. We need to translate all of it because.
Okay. So let's start
that's the kind of stuff that only a lawyer can understand.
Let's start with like the first questions that the justices posed to the defense. So, I'm just going back to my notes. So the very first thing that they were like very focused on was if they find that he had not only like the right to heard, but a greater right to participate, can they rely on this harmless error issue? Meaning there's no prejudice. There's nothing that the victim can show would have changed the outcome of the hearing if he didn't get that extra level of participation. And they asked this as a hypothetical. And, they do that, and lawyers are sort of like, you've got to kind of fight that hypothetical so you don't lose your grounding. But in that hypothetical, the answer is you cannot have harmless error, because then it's completely worthless. If the court is finding that the victim's advocate or the victim has a greater right than merely addressing the court, to actually participate and to have a lawyer speak for them and to, challenge the evidence, they can't say that that was harmless. And, I don't know, should she have given on that issue? Maybe. But then,
all right, wait, let me interrupt you for 1 second. Explain to our viewers, what does harmless error mean? Because to non-lawyers, that's just two words put together that mean nothing. So what is harmless error in terms of the judicial system?
So, there's a lot of times where the court makes, some kind of mistake, and they're on appeal, and the defendant is saying, and I'm trying to think of something that would be considered harmless that I can't think of right now. But the court should have let this person testify. They should have not overruled this objection. They have to kind of follow it out. And if that would have been allowed in, it would have changed the outcome here because of X, Y, and Z, not just that an error occurred. It has to have been significant enough to have changed the outcome. Now,
that's the key.
That's the key. So if all they find is that he had the right to attend, then harmless error needs to be the issue, because, all right, there's no error. Secondly, if they find he had the right to speak, more than this greater right to participate, but just to be heard, then, I do think they should do a harmless error analysis, because he was heard. And what more, maybe they could have, in that case, he could have included what more he would have said or done. So the court also, was focusing on, with that, that hypothetical for a long time. So, and I don't know, does that mean that they were sort of, like I was saying in the beginning, trying to shift her over enough so that they could get her? Or were they making the point like, we don't have that here, so that's why we're requiring harmless, kind of thing? And then they went to
well, let me ask you something. So, and this is kind of one of the bigger questions, and I just want to explain to people procedurally how we got here real quickly. And Allie, were you able to do your Zoom while that was going on?
I did.
Hey, we got her, folks. We got her. She doesn't have to go. So that's super exciting to me. All right. So procedurally, what happened? And again, what was going on today had nothing to do with the underlying case, the facts and evidence in the underlying case. This was all relating to what happened 20 plus years after the trial took place. What happened back last year is that the state's attorney, actually, pursuant to a relatively new statute, which you heard Young Lee's attorney talk about, which was drafted because of this gun trace task force that was the rogue cops in Baltimore that were robbing drug dealers.
Right. If anyone watched The Wire.
No, and it's not even The Wire. It's
the real one.
Yeah, it's We Own This City.
Yeah.
We Own the City. It's amazing. It's 6 episodes. I highly recommend it. And it shows you just how much power and how bad a bad cop can be, or bad cops. But at any rate, so they created this statute, which actually it did not exist in the world, and at least in Maryland.
2013.
Right. I think it was later than that. Did you look up when that statute came?
I did. I'll double check myself while you keep talking.
I thought it was 2019. I thought it was more recent.
I could be wrong. So
but what that statute allowed was for the state, okay, to actually come in and say, you know what? We've relooked at this case, and we agree, for whatever reason, whether they found a new suspect, or they found somebody else that may have done it, or in this case where they felt that after everything that they reviewed it thoroughly again, that Adnan did not get a fair trial. Like, that was the grounds in which they came, and it was the state that filed the motion, not the defense. The state said, look, we agree And it's our position that Adnan's conviction should be vacated, which means it's wiped out. So after that happened, okay, they then have to have a hearing. So they file that motion. They then had to have a hearing. And what you're hearing about with many of these issues today was the fact that young Lee, who is Heyman Lee's brother, was not given proper notice of this hearing taking place. All right. And if you read those motions and if you start reading the replies, I'll break it down in a very short fashion. But it's basically that, look, he got an email and a phone call one day. He gets a phone call from the prosecutor saying, hey, we're filing this motion to vacate the conviction of the person that this office told you killed your sister. Okay. So one day notice on that. So he's had heard nothing about it going into it. You have to imagine from young Lee and the Lee family's perspective, how stunning that must have been, because everybody, like, you know, victims and their families, if you're talking about murder and you're just dealing with a family, are relying on what the state is telling them, that they got the right guy, that we're going to get a conviction on this. We're going to get justice. So you have to imagine going through 15, 20 years of appeals where you're always on pins and needles as to whether or not the person that was convicted is going to get a new trial, or, you know, if it's going to somehow, like it happened here, it's going to get vacated. And they're saying, okay, well, we're taking it back. He was convicted, but we're saying, no, now he's not convicted. So that's what happened. So he didn't get proper notice is what he was arguing. And he got the phone call, an email, another phone call. And this was happening 3 days before the hearing was set, 3 or 4 days before the hearing was set.
So it was the notice he got was on the Friday before, and it was happening on a Monday, because they
Monday,
said
right? So he had
one
the weekend.
business day's notice.
Exactly. So ultimately, that day, like he said, I don't know if I can arrange to get there that quickly. I've got a job, you know, I've got to book a flight. It could, you know, could be cost prohibitive for me. There's a lot of reasons why you should give a victim's advocate notice, you know, but their argument was that it was improper. So what happened then is the judge said, okay, you know, he's not here in person when the hearing went on that following Monday. She said, get him on Zoom. And I'm going to allow him to make basically a victim's impact statement during the Zoom, which he did. And at that time, he spent a lot of his time, and I believe rightfully so, saying, look, I feel like I should have been there. You know, I had no time to prepare for this. This is a huge thing to me and my family. This isn't just like some day in court. You're letting the man that you've told us killed my sister and my parents' daughter free. And you haven't given us the opportunity to respond. So it's a valid argument in terms of.
But somebody is pointing out there that, you know, like they did. So on September 12th, 2 days before it moved to vacate the conviction, the state contacted Mr. Lee again to provide him with advance notice of the filing. So I think it started with, because this is the second time they contacted them. Before filing the petition, the state notified Mr. Lee and offered.
The day before.
No. We're talking about before even filing the petition. They notified him and offered him to answer any questions that he might have. So
the day before they filed it. I'm pretty clear on that. Like, I think if you look at
all right, but it doesn't matter. So I'm just saying we're talking about the time between the hearing. No, but I mean the time between the hearing.
It was like, what I'm saying is it was like 5 days total. Like he found out there was no advance notice that like what I'm saying, Allie, is that as soon as they realized, like 2 months prior, or like while they're investigating this year-long investigation into the case again, do you think that they could have maybe as a courtesy told the Lee family, hey, we just want to let you know that we've been relooking at the case. We think that somebody else may be responsible for that. I do. If you don't, I mean, you're a hardcore defense attorney. I mean, I am too. But
no, I was just going to say from a victim's perspective, I don't know. I haven't given enough thought to this, but my first instinct is like, do you really want to start upsetting and like getting the victim all worked up and like relive this if you don't even know that such an investigation is going to go anywhere? I don't know. I haven't given it much thought, but that's kind of
But
I wasn't thinking of it from a defense lawyer perspective because I don't think it changes, anything for the defendant. I just
well, I
think
have a
that,
response to you. So if this was a normal case, if it wasn't Adnan Syed, the subject matter of Serial, which really put podcasting on the map, if it wasn't that high profile of a case, and like where we have to wonder what Mosby's motivation was, because you and I were having this discussion, and Carol Mosby was the prosecutor who decided to basically reopen the investigation. Okay. And so this went on for a year. So had it been just another case, I would agree with you. But when it's this case, and when you know what ultimately the result was, you have to wonder what her motivation in doing this was. And if you don't know anything about Mosby's background, she had picked up federal fraud charges, and she was not going to be running for reelection to be the state's attorney. She had done something with respect to COVID relief and had skimmed money from the government. She got caught on it. So she's got this fraud case not related to her office. Well, I think it seems pretty in stone.
well,
Yeah, Marilyn Mosby. Thank you. Michael, I appreciate that. So, man, I got a lot of names running through my head. We cover a lot of stuff, bro. So ultimately, what I'm saying is they knew. What I'm saying is they knew going into that investigation what the likely result was going to be, and I'm suggesting that it could have been brought up at some point, because they certainly knew about the two alternate suspects. They certainly knew about certain things, even 7 months, 8 months in. All right. So I'll give you the first 10 months. How about 2 months left in the year? That they say,
so
hey,
once that they find out that there is actually legs to it, I think for sure that they should, give a heads up to the victim. But, I was just saying initial, like, I'm going to start investigating. I don't know that that's right to like.
I gave you 10 months. I gave you 10 months. So now you have 10 months. I think 2 months would have been like they're deep enough into the investigation. My whole point is, I think the Lee family deserved to know. I think that they should have been given a heads up. So you're like, because your option is body slam them and just out of the blue let them know which is what happened, or give them some proper notice. So I mean, these are the things that they're going to be weighing in terms of the justices when they're trying to, it's the law, but it's also as to the victim's rights. So these are the conversations that are going to be taking place with these justices when they're trying to come to a decision in terms of, all right, how far are we willing to go in terms of, to me, there should be an absolute notice statute that gives a definitive date. 14 days. Put a date on it.
Because, that's 3 days. 3 to 5 days is what notice statutes typically are.
If they're going to vacate a conviction, I disagree with you.
Hearing is 3 to 5 days. So why would it be different to vacate a hearing?
A conviction, not a hearing.
Sorry.
Yeah, no, I don't know. I think it's a bigger deal than you, I guess. I don't know. We're allowed to disagree.
No, I'm just saying, under the law, have you ever heard of a statute that says, but this hearing's more important, so we're making notice longer?
Yeah, I have. There's notice statutes. We know, like, an appeal, they have deadlines.
No, but that's not a notice statute. That's completely different.
Yeah, I think there are more important motions that are filed. I think when it goes to kind of the crux of the case, in terms of you're talking about a criminal case and it's going to the victims and their rights, I think it's different.
Yeah. Okay.
So I don't understand like why you're upset. Like I'm just trying to like you're shifting in your seat.
Actually,
so y'all are getting to see husband-wife action.
No. I moved my legs on top of the chair in front of me. So that's why.
Yeah.
No, I did. Like I have my legs out in front of me now.
All right. So we'll agree to disagree on that particular issue. All right. So the other issue that I want to talk to you about is what I think that there were two really big issues. Is as much as I think that's an important issue. I think that the big issues are, first, the mootness issue in terms of, because what a lot of questions that I've been getting are, okay, so how does this affect? And so we're going to go back to procedurally. So Adnan, he's out. Okay. And then young Lee hires a lawyer. He says, I'm upset and I want you to file something because I don't think I was treated fairly. My family wasn't treated fairly. So they do. And the court doesn't agree with them and doesn't grant it. They then appeal it. And the appellate court agrees with young Lee. And what they do is they went and they reversed the vacatur of the conviction, making Adnan convicted again. So he was reconvicted because the appellate court disagreed. And they said that they felt that that was a sham of a hearing because essentially, and if you saw the hearing or watched the hearing, which I did, I can't remember if you did, Allie. I think we were listening to it together. But ultimately the appellate court held, look, you can't just come in and read your motion, which is what she did. Exactly.
Right.
That's what
Right.
she did.
But the appellate court had no right to be speaking on that issue. To be perfectly honest, that is all dicta. And as you see, the Supreme Court, they didn't touch on that at all. What should have happened at the hearing? I mean, they touched on, the fact that it was in chambers, and that was like something important that I noted, like in my notes that I have like to discuss about this, was that they can't say there was nothing adversarial. Like the Mr. Lee's attorney is like, there was no challenge to this. There was no adversarial eye looking at it. Well, what do you mean? The judge looked at it in chambers, and the judge.
It's not adversarial though.
Well, presumably the judge is giving a keen eye to balance.
Well,
I don't know. It's what the Supreme Court mentioned too, by the way. That's what the justice said. How do you rectify that when the judge looked at it?
All I'm saying is it wasn't adversarial because it's a very unusual circumstance where you have the state filing a motion to vacate a conviction. And of course the defense is thrilled.
Right.
You know what I'm saying? So, yeah. Right. So it wasn't adversarial in nature and what the appellate court, but you kind of jumped ahead because like, that's what I wanted to ask you. That's really what the question is. And you may have answered it, but in terms of what's going to go on now. All right. So if the Supreme Court of Maryland is silent as to that issue, they didn't address it, does the remand, when the appellate court said, look, you're going to have to go back and you're going to have a substantive hearing. We expect witnesses and we expect evidence to be put on. Is that going to have to happen? Or does the Supreme Court just say, because like you said, they didn't address it? You know what I mean? So obviously the issues that they're going to be dealing with, the 5 that they dealt with today, does not include that issue. What is the impact of that appellate court's ruling in terms of whether or not they're going to require a substantive hearing to take place?
As I see it right now, when I mention the word dicta, because I'm sorry, most people aren't lawyers here. Dicta means when a court speaks on an issue that's not properly before it. The victim has a right to appeal a violation of the victim's right. I didn't get notice. I think I should have participated more. Not to say there was something substantially wrong legally with the way the hearing went down outside of that. There wasn't enough evidence. They didn't meet their burden. These are not issues that a victim gets to raise in an appellate court. And although I strongly support a victim being able to raise the violation of their appellate rights, I, from both sides of the aisle, can't imagine a world where we now incorporate a victim's ability to challenge the defendant's conviction, period, or to, in support of, if the evidence was suppressed and now the victim wants to appeal and say the evidence should have never been suppressed. That in no world can that ever happen, especially given, what's going on now. So in any event, when the appellate court took up those issues, that's what I'm saying is dicta, because it wasn't an issue properly before the court. Now, I think what the court should or could, or what I think it should do, if it found that the victim had a right to be heard. And if it decided that its right to be heard was not fundamentally fair because of the circumstances, he's like, I was flustered, I didn't get to say what I wanted to say, that they could reopen proofs, meaning we're going to, not that the hearing never happened, but we're going to reopen proofs, let the guy talk. If the court's decision is the same, then the nollie pros would stand. And if not, then obviously it wouldn't be vacated. Like if the judge still finds to vacate, then the state's decision to nollie pros would stand, because that would keep the status quo as much as it could and recognize the victim's right is an important right that should have been acknowledged more. He should have had more of an opportunity to talk, because I know that the court doesn't want to, I feel like they're going to want to find a balance, but they could find that balance by a lot of lofty language saying how important victims' rights are, but that they're faced with the black letter law. And this is an issue for legislature. When you and I were talking about this before, it's an issue for legislator. They do not have a specific right there. The Supreme Court cannot just be creating new law, especially when you're talking about new law that only happens in a situation where the defense and the prosecutor are on the same side in a very narrow, issue.
Right.
Well, and I forget where I was going with that, but I was starting to say that it was dicta. So I think that the Supreme Court, though, can give an advisory opinion, which might also be considered dicta, but they've got a lot more teeth when they get, and they could give, and maybe that wouldn't be dicta because it would be an advisory opinion. So they could go off and say, we want it to go back and we want this guy to get the hearing. And we also want you to do your in-chambers meeting on the record, meaning with a court reporter, so that at least the Supreme Court can review it later if anybody raises another issue with this. I don't think they're going to make them put it all on the record. The Brady violation part, I don't know, because if I forget what it actually was, can you remind me?
Yeah, I mean, there were a couple of things, but before we get to that, because I don't even know that that's germane. I mean, there was a few things. There were a few alleged Brady violations, but I kind of want to translate you because you're brilliant, but you're a lawyer, and you do kind of forget that a lot of our people don't know a lot of the words. So I see you getting frustrated when I explain things.
No, not at all. Not at all.
I know, but I do it because that's what I do.
Get it. Right.
I'm trying to make it so that our listeners understand. I didn't go to law school. All right, cool. So, so what Allie's saying in terms of using the word dicta, like when you're reading, if an appellate court has a ruling and it's in writing, and they'll discuss the issues, because when you do an appeal, you outline each individual issue that you say you're going to
presented that you read to them. That's the issue.
Right. So those are issues, and the appellate court sticks to those issues exclusively. The only thing that has weight, the only thing in terms of what they call a holding, which is their ruling, which the lower court has to abide by, are those issues. So when Allie's talking about dicta, when we read through Adnan Syed and their ruling in terms of the appeal, the appellate court went way beyond it. So instead of just talking about those issues, they then dove into what Allie was talking about, that they had no business sticking their nose in, which was the whether or not that hearing was substantive or not, because that wasn't an issue before the court. So that's why she's saying that wasn't something that they should have been talking about at all. And up at this level, at the Supreme Court level, it's not before the court, because it can't be, because it wasn't an issue before the appellate court, and everything moves up the ladder in terms of the appellate issues. So if it didn't exist at the appellate level, that means it can't exist at the Supreme Court level in terms of them basically appealing to the Supreme Court on what the appellate court said. But because they stuck that language in there, the fact of the matter is it clouded the issues much, much more. And it created a really terrifying situation for Adnan Syed and his legal team, because it left in kind of a scary position. Well, is there a chance now that Mosby's not in office anymore? We've got a new prosecutor that's looking at this. Is it possible, which is leading me to ultimately my end question, is it possible? Is there a world, and I know the answer. So remember, we've had these conversations, but our
I think you
listeners
know the answer.
well, I unless you've changed it since I asked it the first time.
Oh, you know my answer.
Your answer.
Okay.
So as far as, is there a world in which you can see that the prosecutors can say, look, we're withdrawing the motion and we are not seeking to vacate the conviction? Because right now they stayed it, okay, which means they delayed it. So remember, the appellate court, they said we felt it wasn't a substantive hearing, and because of that, we're overturning the vacation of the conviction. Adnan Syed, you are now convicted again of murdering Heyman Lee. When it got brought up to the Supreme Court, what happened is the Supreme Court says, nope, everybody calm down. We're going to stay it. We're going to delay what the appellate court said. Okay, we're not vacating the conviction, or we're not reversing the vacation of the conviction.
I'm sorry if I can interrupt real quick. That happened by way of a motion that Syed filed asking the court to stay the conviction, and neither the state nor Mr. Lee opposed that motion, which has basically the legal effect of consenting to it. So everybody essentially agreed to stay that, which would allow him to stay out of jail while this issue was being considered.
Right. So, but it moved it back in time. So correct. It's like they said, hey, appellate court, you can calm down because we're going to put it back to where the conviction was vacated. So that's where it currently stands. So that's what my question is. Is there, in your world, in your brilliant legal mind, is there any way in which that can happen? That being where the state says, look,
we withdraw the motion.
Did what she did. We ain't feeling it. And you know what? We're withdrawing the motion and we're not moving forward. Like, can that happen in any way that you see possible?
We just freeze?
I don't think so.
Oh, on my end it did. So as long as you guys didn't, then I'll keep talking.
Yeah, your picture's frozen, but I can hear your voice, which is weird. Like, yeah, you're frozen. Am I frozen for you?
For me, yeah.
Oh.
I'll try to fix it and keep talking.
Okay. Can you guys hear us? All right, here. I'm gonna remove you out, put you back in. Let's see. Yeah, how's your internet connection? Am I frozen, y'all? Put it in the comments. Allie's frozen for some reason. Dude, our Wi-Fi is whack. So I am, but you can hear us. All right. Well, hopefully the internet resolves. I mean, I couldn't have purchased more of those boosters for our house. We got to go direct connect. That's all there is to it. All right. So hopefully, Allie, maybe log off and log back on.
I'm trying. I'm frozen. Like I can't even. It's not letting me refresh the page or anything. So just give me a moment and you guys talk about whatever you want to talk about.
Okay. All right. So while we're waiting for Allie to get back, why don't you all throw some questions? If you guys have any questions in the chat.
Well, check the start side to see if somebody with
yeah, we haven't got any more stars. Oh, Carly came through with a super sticker.
All right.
Thank
so
you,
answer
Carly. I don't have the cool music yet, like to celebrate when somebody is generous enough to give us money, their hard-earned money. We adore that. We appreciate that more than you guys will ever know because we put a lot of work into this. And, we appreciate that you appreciate us by showing us the love with your hard-earned money. So we will always be giving you love. And I'm just telling y'all that Allie, as you can tell, she don't play. So if in her rule is going to be that we're not throwing up quite, because I'm a softie. Like if I see a good question, I throw it up.
No, I want to know if Carly has a question since she just paid for a super sticker.
Yeah, well, your rule is going to be that, if you're not a member or if you haven't thrown a super sticker up there, we're not putting your question up, which is a hard line. I mean, she's tough.
Well,
you guys see how you guys are like, you guys see how she beats me up. I mean, how do I deal with that kind of like brain, man? It's like
Oh my.
she's so brilliant. It's so hard to deal with. So all right, Carly, do you have a question because of your super generous, fantastic super sticker? Anything? So Adnan is not in jail right now. He is currently, yeah. What is going on? I think you got to jump off the Wi-Fi and jump back on. That's what I think you got to do. That's weird. We're in the same house, yet she's frozen and I'm not. All right, I'm scrolling through here. So Denise, that's what we're talking about. The new prosecutor. I mean, at this point, when something is appealed to an appellate court or the Supreme Court of the state, everything is stayed. Everything is frozen in time. That means that nothing can take place in the lower court level. So until we get a ruling from the Supreme Court, and they have no time frame in terms of, how long they have to in order to write out their opinion on the case. And essentially what they do, like much like the Supreme Court of the United States, in any kind of state Supreme Court, is those 7 individuals are going to go back and they're going to discuss it, and they'll have heated debates about things. And ultimately it's a majority rules type thing. So now we had 7 justices up there, which again, I was like beyond thrilled that 5 of those justices were women. It's so long overdue. Sorry to all you dudes out there, but it's time for women to run shit. Like I've been saying it for years. We had our shot. And this is where we're at. So we got to change the game up here. And to me, that like just warmed my heart to like I couldn't believe it when I saw that there were 5 women justices. I was so excited about it because men and women just look and think about things differently. Like that's why I was bringing that up in the chat in terms of, yes, they're always going to use logic. They're obviously brilliant women. That's a given. However, I find as a general rule that women tend to be more empathetic than men do. Just as and maybe that's a gross generalization. And if I'm an empath, so I mean, certainly there's empathetic men that exist, but like if I were to kind of weigh it, I would say, man, women are definitely more empathetic than men. I mean, they're more nurturing just because of the way that you guys bake babies in your bellies and you can make life. It's a different thing. So I think that kind of common sense will come into play in terms of when you're talking about these kind of decisions where you're talking about victims' rights. So then maybe as opposed to like 7 men sitting up there, 7 old white guys, telling the victim to rub some dirt on it and, suck it up, buttercup, that kind of stuff. So, that's just how I feel about it. Huh? Are you working?
Here.
Oh, sorry. Oh, ew! All right. She's back, baby. All right. So, I was just praising it because I was blown away by the fact that there were 5 female justices.
It's good to see. It's good to see.
I thought it was amazing. I thought it was such progress. All right. So what did you find striking about it? Like, I mean, do you want to kind of go through? So, I mean, you didn't really get to answer that question. Is there a world in which you can see them not moving forward?
Okay. So in a general rule, okay, anyone who files a motion before it's heard can withdraw the motion, but it's not like what you said is not of record. And in this case, the state actually proceeded with it. So even if the court were to say it's like we're back in time, we're dealing with criminal law. So we're dealing with, like the search for justice and, all of those things. So what they said in that motion is never leaving. So I think under you could use the law of the case doctrine or something like that. What the state did and said already exists. So I would hope they could rely on that to at least compel the state to they already proceeded on it. Even if they find it was, a nullity or a void, they already found that the issues were sufficient enough, significant enough to move forward. Now, if they, So hopefully that's not an issue. I suspect that the Supreme Court's going to do everything in its power to avoid that, which is why I'm talking about them. And no one asked for it. So it's a little unusual. Like no one said that I saw, and I don't know if I actually got to the overall remedies in the motion, but no, it wasn't touched on here, that one of the reliefs requested was if you find that there was something improper, reopen proofs, meaning, like sometimes we have a hearing and then you learn something afterwards, or you like forgot to put something in, and like you run in and you're like, we need to reopen proofs. I just found this new thing, or I forgot to do.
Like, let me translate. So like there's the state's case in chief in a trial, and there's the defense's case in chief in a trial. And during during any trial or a hearing, there's going to be a point in time when the judge is going to say, okay, is that all of your evidence? And they're going to say, okay, yes. Okay, well, I'm shutting the proofs down, meaning that you, as a general rule, as a general proposition, you cannot come in and say, all right, I forgot something. It was sitting right here in my pile. Sorry, judge, I'm a little disorganized, but here, so if they've shut the proofs down. So that's what Allie's talking about with reopening proofs, because typically when they shut them down, that's it. Like no matter
right,
what,
when a hearing's over, when a hearing's done and concluded, right. So you could, but that is a way, a loophole around it. Reopen the proofs, allow him to talk, allow him to participate in whatever way they decide. And if it does change the outcome, then I think the state's not, right. The bigger fear is, would the state be bound by its decision to nollie pros? Oh, go ahead. You want to say something to Dara?
Yeah, I was going to throw a shout out to Dara. Is it Dara or Dara? If so, give me a thumbs up if it's Dara, how I would typically pronounce it. And give me a thumbs down, or no, give me some kind of sign.
Well,
if it's Dara,
so I say that as Dara, and maybe it depends where you're located.
Right. Maybe it's an East Coast thing, maybe. But I mean, we have a lot of viewers that are out of the country that aren't even.
So
US
what is
folks.
the next step? What she heard about a November hearing, that's the next time that the Supreme Court's hearing a case. So that November 7th date didn't have anything to do with this case. It had to do with when they are next hearing oral arguments and their schedule. So there is no, I don't want to be quoted on this, but because I haven't looked at Maryland's rule, but often there's no time frame, like for the judges.
I already threw it out there. So if you're wrong, I was wrong first. I was like, there's no set time where the Supreme Court has to come down with the ruling. So I'll be the idiot if I'm wrong about it. I said it before you did.
Well, thanks, babe. But
no, so bullet for you, girl.
I know you will. So it's just going to be a matter of how long it takes them to decide. They will issue a written ruling with a mandate. The mandate is basically what they are telling the circuit court to do. Right.
All right. Denise, boom. Look at that.
Yeah.
I mean, I got to figure out, like, so we use StreamYard. Jay at the Shaming of Jay, which I know a ton of y'all are fam. He's got it, both them and Steve and Dan at Publicly Buzzed have like just great like sound clips for when people like do a blasm and they give us, super stickers or numbers. It's like I got to figure it out. Like I can put like an entire song in, but I'm not trying to get copyright violations. So it's got to be like I can't figure out how to do sound clips because I got some good ones. Like I know what they are.
You are a sound clip. Just do something.
I know, but like it's fun to have the sound. Like I want to do sound. I
know.
I've got so many clips that I want to use.
We're going to figure it all out.
Super generous. All right. So Denise, thank you.
If you've got a question, throw it up there.
It's amazing. I love it. All right. Let's see. Yeah, Denise. I mean, you just bought yourself a couple questions with that $9.99 super sticker, woman. I'll tell you that right now. All right. So as far as I think that we kind of addressed the second issue was, does a victim's representative, a non-party to the case, have the right to attend a vacator hearing? Obviously, yes. So the question is, do you think Zoom is sufficient? I mean, it's our modern world.
Right. So what I think the court is going to say And they talked about this, about what is practical and should the victim's rights be considered. I think the court would say that the law assumes that the victim's schedule and stuff will be considered. And when practical, it will be, it will be incorporated. I do not think here a week-long request was too long. I mean, what you and I said from the very jump is, why in the hell, just to avoid all issues, didn't the judge give this a week? And maybe it's because of what that judge heard in chambers. Maybe the judge was so moved by the evidence and the issues and, whatever, that she's like, no, we're not leaving what now I kind of feel is an innocent man in prison for another week. I would assume if she had like a rewind button, she would just give the guy, a week. But
which is all they asked for. Like
right.
I was throwing that 14 days out there, but all they asked for was 7 days. Like what I was saying from the get, I'm like, if I'm Adnan Syed, I'm going to my lawyer and I'm saying, I don't dude, I've been in here forever. Like I ain't sweating this guy to give him 7 days. Give him the 7 days to avoid all. Had they given him the 7 days, today doesn't happen. You know what I mean? It's like, to me, that was a no-brainer. Same from the state, like from both sides of it, I'd been like, and the judge, I would have been like, yeah, you know what? I'm going to kick it to next week. I realize that Adnan's been in there for a long time, but I mean, to me, it would have just avoided all this.
Yeah, the defense, we were talking about that at the time. If it was our case, we'd be telling the judge, oh, yeah, please give the guy the 7 days.
Right.
Especially if I already know from an in-chamber discussion, you're all doing what you said you were going to do, and this is going away.
Right. It's like I'm walking.
Risk it. Right.
Yeah. Like I'm taking the 7 days to say goodbye to all my homies in the joint that I've made over the past 20 years.
I think that they are going to find it sufficient if it is just the right to attend. And that's really the issue here. If it's more than the right to attend and involves the right to speak, they might still find it sufficient, but involves the right to participate to any greater level, then I don't think they're going to find it was sufficient. But I can't imagine
that, because that's the fifth one. So the first and the fifth to me were the biggest issues.
I like the harmless error issue personally.
You like that one? Well, I'm about to give you. So the harmless error one, I think that, all right. So 3 was notice to the victim's representative of the vacator hearing. Was that sufficient where the state complied with all the statutory rules based notice requirements?
I think that the court could find that that was not sufficient, not because they did comply with it, but the judge, I think they were calling it, what word did she use? She was like, it wasn't the notice itself, it was the nature of the notice, or it was the I can't remember the word they used, but they're like, all right, in theory that you gave enough time, but under these circumstances, it was like notice that could never accomplish anything. But then I think that would be a harmless error. I think that they are going to find many errors that they deem harmless because they want to support victims' rights, and they don't want to be undercutting victims' rights. And I think the biggest issue they have with that is your first issue that you said was so important about the mootness. Because I don't think they're going to want a situation where anytime you're dealing with something that is like final in 30 days, that the victim's right to appeal just becomes moot. But as it stands right now, with the way the law is, it doesn't. It kind of appears that it would be moot. And they may also come back and say, we need legislation to address this. We want our legislatures to take this issue up so it doesn't happen. But I can't find here an issue because I wish this is what the statute said or the law was, even though it's not.
Right. And I agree with you. Yeah. I mean, the thing with the statute, like the many statutes,
right. That's what Frankie is right. That's what she said. That it was all right. So notice was sufficient, but what about the quality of the notice? And I think that they are going to.
Frankie, by the way, has been on point in the
Yeah.
whole chat. Frankie, I just want to give you a shout out, man, because or ma'am,
Or
whichever.
right.
Frankie's a androgynous name, so it could be a gal or a guy. So, but you've been on point with all your comments. I've
Human.
seen all of them. Huh?
Frankie's a wonderful human.
Human, yes, yes. So as far as but like with all notice statutes, a lot of them are amorphous, which goes to your earlier point. You can't treat one notice statute differently than another. You can't give one more weight than the other, which I was arguing for argument's sake, but I, in reality, agree with you. And you guys have to realize that when I'm devil's advocating with Allison, I'm doing it for your benefit. For the most part, we typically agree pretty much on everything. But
I
to
wouldn't
make
go
the
that
show
far.
interesting, I like to take the counter. I think we agree on way more than we disagree on. So
For
as
sure.
far as that goes, but a lot of times they don't give. They talk about reasonable. They use the word reasonable in a statute. Give them reasonable notice, which was the case here. There was no deadline. There was no definitive date or number of days in which they had to give them notice. So, in reasonable is open to interpretation, which, as I tell our listeners all the time, that's what lawyers do. We interpret statutes, we interpret the law, and we argue about it. That's like what you saw today were 2 lawyers or 3 lawyers or 4 lawyers arguing about what these statutes mean and how they should be applied. That's what appellate court is. And what Allison was saying earlier, and I don't want to give you a civics lesson, but the way that laws are made is we elect our legislatures, our House and our Senate. So when you guys do those, go to your voting booths and you're like, I never heard of this guy. I'm going to vote by party, or I like this guy's name. Well, it turns out that those are the people that are actually drafting the laws in our states and federally. So once those get, and they call them House bills, and a House bill then gets thrown through the Senate, and the Senate says, okay, we agree or we disagree. If we agree, it then goes in the state, goes to the governor. If the governor agrees, he signs off, it becomes a law in the state. And for federally, it's the House, the Senate, and then the president. So then that becomes a law, federal law. So once a law is made, and a lot of senators and House reps are attorneys, but not all of them, so they're writing these laws, but they don't know how they're going to apply in practice. So
And
that's where
the courts come in.
That is, and that's where lawyers come in first before the court. So lawyers are going to say, okay, I'm reading this statute one way. And like if Allison and I were on opposite sides, we'd be saying, okay, well, I'm reading this word to mean this. And Allison's saying, I'm reading this word to mean that. And then we go in front of a judge, and the judge is going to say, okay, well, I agree with Allison. I think it's that. And then I'm going to say, well, that's BS. Now I'm going to appeal it, and I'm going to go to the appellate court. We then make the argument there. And the appellate court agrees with the trial court and says, I agree with the trial court who agreed with Allison. That's it. Now I could continue to whine and try to bring it up to the Supreme Court and say, well, the appellate court's wrong too. Trial court wrong, appellate court wrong, Allison's wrong.
And the Supreme Court won't hear. Sorry, babe, I interrupted you.
Oh, it's okay. Go ahead.
The Supreme Court doesn't hear every issue. You have to request the Supreme Court to hear it. So here, one of the things they argued a lot in their written motions was how this could affect other cases. So same thing with like Zoom, whether the Zoom was effective or they needed to be in person. And I think the court's going to say that Zoom is very effective, but when a victim elects to be in person, that should carry great weight and should be, attempt to be accommodated when practical, or something like that, because they can't find Zoom is not sufficient because they have found Zoom to be sufficient in so many other ways. Although there are times when Zoom is deemed insufficient, like the defendant would have to waive their right to be in person. And here we do that almost for every hearing, sometimes even when there is not witnesses going on. It sounds like in Maryland, they've got specific statutes saying that is sufficient. And maybe the defendant doesn't need to waive unless it's a hearing where evidence is being presented directly. And the same thing goes for this extended right to participate. If they do that, it's going to have a huge impact on the way every single criminal case is is from start to finish handled. And I don't know where, and you got the post-conviction stuff. You don't have a victim's right to come in when someone's filing a post-conviction petition saying, hey, I've got newly discovered evidence of my innocence, judge, think it over. You don't get to have a victim's advocate there or a victim's representative or a victim saying, well, wait a minute, I don't think that's very compelling. But if he's trying to get parole, he's trying to get his sentence, if they're resentencing him, then yeah, a victim has a right to be heard and a victim has a right to say how the crime impacted them, because that is a factor in sentencing and parole and things like that.
100%. Oh, Jedi Platypus coming through with $5 holla. All right, so Allie, you're not on Jay's stream like when I'm on there all the time. There was one stream where Jay was trying to get something done, and it was back when he was streaming trials, and somebody and Jay was desperately trying to get this done, and this one particular viewer kept asking the question, is this the verdict? Is this the verdict?
I was going to say, can you ask her to clarify that? So
yeah, so it was hilarious. So that's kind of my running gag with him. Kind of like when I had the shirt on the other night and he would just kept firing on the shirt, which I love. I don't care if y'all loved it or not. I'm like, I said, like today I'm in professional mode, but like I want to be wearing some loud shirts, y'all, just so you know. And I want to ask in the chat, is this super boring to y'all or is this good content? Because like we can law nerd out all day, but we want to make sure that y'all are finding it interesting, because we think it's interesting doesn't mean that y'all think it's interesting. So we just want to make sure that you guys love the content, because that's the whole point. We really want to make sure, and we want you guys to understand, if you love true crime and you want to understand what's going on, what you're watching and terms that are used, that's what we're trying to do. But we're trying to do it in an interesting way. And, we hope that you're enjoying it, because that's why we're doing it. I mean, Alice and I could easily do this by ourselves without torturing y'all. So hopefully you guys dig it. I'm seeing in the comments, it looks like y'all are kind of digging it. So we appreciate that feedback so much.
And Bob, because we're wrapping up, it seems, at least anyway, or you're thinking about it, I just noticed an entry on the docket that I'll talk to you about off camera later, but this feed might not be posted till tomorrow. As far as we're doing it live right now, but we may not post the recorded version of this till tomorrow.
Yeah, and because we took a little bit of a shot here.
No, that's it. That's all we're saying.
Okay. All right. So all right, y'all. Let's go to 4. So 4 was, must a victim's rep seeking a reversal show prejudice on appeal? So that was,
I think absolutely.
Well, explain what that means to the people, because so
that's what we talked about earlier with harmless error. They have to show that the outcome would have been different. Something would have changed. So again, I think either way, you have to do a harmless error analysis, but you cannot find it harmless if the Supreme Court finds that this victim's advocate or victim's representative, Mr. Lee, had the right to participate in any sort of meaningful way. Because if he has the right to participate in any sort of meaningful way, they cannot say his lack of participation is harmless. They don't even know what he was, that would undercut the entire thing. But I don't think they're going to get that far, that he has this higher level of participation. For right now, he had the right to attend. So there is no error when you attend via Zoom. You couldn't have changed the outcome if your only right is to attend. Now, you have the right to be heard, to speak. He did get that right. How much more could he have said? That could still be harmless, right? No prejudice there. Right. He had the right to meaningfully participate, challenge the evidence, put on some sort of witness. Surely that cannot be considered harmless in any world, but I cannot imagine the court is going to take it to that extent. But
let me jump in. So, but this, out of all the issues, this is the one issue where they might be able to shoehorn what I was talking about. Like this, where I'm saying, where there could be an avenue in which the Supreme Court of Maryland could say, all right, well, we are going to fight, because what they're talking about seeking a reversal. We're talking about seeking a reversal of the motion to vacate. Right. So, I mean, so they did address it a
If
bit.
they want to, right.
If they want to, but that's what I'm saying. I mean, there
could
does exist.
I'm sorry. I think even, so let's just say he had the right to be heard, which they may find he had the right to be heard like he does at a sentencing hearing.
Right. Like a victim impact statement.
Right. They could find that that's not ever harmless, because that they have that right. So it can't be harmless. And that, and here you have the facts that they alleged that he didn't really get time to actually speak because he was flustered and talked mostly about the fact that he really wanted to be there. And so his meaningful opportunity to speak and have an impact, as he's supposed to in an impact statement even, and in such a case, it would be my hope that they would reopen proofs so as to avoid the whole, they're going to try to withdraw and we're going to be fighting about a change in the way the state handles it. And was it the law of the case? And are they somehow bound what they said before, even though the hearing wasn't sufficient to support the vacatur?
So what you're saying in lay people terms is that you want them to be able to say, okay, yes, we're gonna reopen the proofs, but only as to Mr. Lee being able to come in and say what he wants to say about what he felt, the impact on his family. But as far as doing a redo of the hearing, you're saying a hard no. So we'll open the proofs. We'll open the proofs for allowing basically the victim impact panel. But no, you're not going to be able to dig into, because I agree with you completely. Obviously, you cannot have a situation, or we cannot live in a world where victims are allowed to start introducing evidence on their own, because it changes the fundamental system of justice that we have. I mean, it changes everything. It adds a third party into it. They then become a party to the action, which is insane. And this is we are victims advocates. They have a voice. They should always be heard. But in terms of producing evidence, substantive evidence in a case, that cannot happen, because it changes everything about. I just don't think it's constitutional. So I don't think that can happen. So is that basically what you're saying?
Yeah. And I also do think that they should, and whatever they do, something to avoid even the possibility of the state trying to withdraw the motion. If they void it altogether and say it didn't exist, like the lower court did, then maybe you are fighting that battle, even though I think it's one the defense should win. But I also think they could do what we talked about earlier with the advisory opinion, that while you're reopening proofs, put the information from the in-chambers meeting, do it again in chambers, but with a court reporter. So there is a record, create a record.
Right. All right. So, and I've seen people are kind of diving into some of the facts of the case, and I just want to address the DNA on the shoe. First of all, Hay, I believe, was not stabbed or shot. I don't know that there would be any blood. So the question becomes, does that DNA have anything to do with the crime? That's the scary thing about DNA on a shoe. I would suggest that shoe DNA is probably the scariest DNA to ever convict somebody on, because our shoes probably have more DNA on them than any article of clothing, including parts of our body, our hands, which touch a ton of stuff all day. Our shoes are every time you go into a bathroom, public bathroom, you probably pick up however many people predated you in that bathroom that day prior to the time that they mopped. You now have their DNA on your shoe. It's a scary proposition. And moreover, we just don't know if it has anything to do with the crime, because I don't think it is blood. I don't think that it's blood that was found on the shoe. So to me, that the DNA, because my thing with this is not, and I'm not going to get into the Adnan diatribe. And there's, if you listen to Brett and Alice, our friends over at the prosecutors, they think he's guilty of sin. They think he's the guy. There's no change in their mind on it. I'm more in the, I'm still on the fence as we're doing our Avery thing, which I recommend that everybody listen to on our podcast. Alice and I are doing the deepest dive that will ever be done with no agenda, no cherry picking. We're going to go through all the evidence. We're actually recording an episode because we're due, but I got sucked into the Delphi stuff, but that's coming. But if you don't listen to our podcast, it's Defense Diaries. We highly recommend it. We think it's pretty damn good. I think anybody that listens to it will probably agree with us. But as far as this case goes, like until I actually dig into it, I'm not going to be able to come to a decision. Do I see a world in which Adnan could have done it? Absolutely. Do I see a world in which he may not have done it? Absolutely. I mean, it exists in both places for me in my mind, but I'm like that in a lot of cases. Any case that's circumstantial, there's always a little bit of doubt in my mind, because I can always try to be like, oh man, I don't know. All right. So enough of that. So 5, is a victim's right to speak incorporated into the vacator statute of Maryland, where no party or entity other than the victim has an interest in challenging the evidence alleged to support the vacator.
So I think one of the judges asked about the time, and I actually had made a note to myself when we talked about doing this that I wanted to look at the date of the vacatur statute and the last date that they updated any statute that dealt with the right to speak. Because I think one of the justices mentioned like, well, it wasn't in existence at the time, so maybe that's why it's silent. Usually when a statute is silent, when they drafted the vacator statute, though, instead of just doing this cross-reference, it's very unusual that they wouldn't just put the right in there. Why wouldn't they have just given the right? And cross-reference is one thing. It's different to say, and he shall have all the rights laid out in statute ABC, and then cross-reference to the statute. So I don't think that the court is going to be reading language into it, but I honestly don't know. And I think that's why there was a lot of comments about legislature. And like I said earlier, when you and I were talking about this, between ourselves, we discussed how this is a significant issue for legislature. And I think that part of the wording of the court is going to be that it's something they are very hopeful that the legislature will take up and address to grant more opportunities to speak, but this is essentially a post-conviction matter. This is a post-conviction proceeding, and they do not have the right in a post-conviction proceeding to be heard. You have motions for new trials. You have, all sorts of post-conviction motions based on newly discovered evidence or actual innocence that they recognize there is no right, like literally because they did there are certain times where the statute says, and you have the right to speak, and you have the right to be heard. So when it doesn't say it somewhere else, it's because they don't have it, period. The end. You can't infer it and imply it. But the state is Mr. Lee is trying to say this cross-reference, the way they use the cross-reference under their rules in Maryland, that is supposed to say, point over that you also have this right. And obviously the appellate court said, no, that's ridiculous. It's not what it means. This was a cross-reference to say you have the right to attend here. See sentencing hearings where you have both the right to attend and be heard. If they wanted to give them the right to be heard, they would have just put the word and be heard right there. And that's something that the Supreme Court always looks at, the way something is worded. And I think we said it, Barbara said it on our last YouTube, the wording of something written is very important. And in statutory construction, which is what we're talking about here, interpreting what is meant and what rights are given by a statute, they go very much by what is written and what is not. And where in other places in the statutes, they have the extra word there. Well, they wouldn't have left it out here and just thought you assumed it. So I don't think they're going to be reading it in, but I don't know.
And they also look at the legislative intent, which is
right, which one of the justices brought up.
Correct. So legislative intent, and like when I was telling you guys how laws are written, typically, the legislature will say, okay, well, our intent in creating this law, creating this statute is this. So the courts will also take that into consideration. All right,
And
Allie,
so real quick, babe, to your point, one of the justices brought that up. He spoke about what they talked about in those hearings. They're all recorded. And when you talk about legislative intent, they will go back and say, I want to know what was discussed on the floor when this bill was proposed. So that judge said, it sounded to me like they wanted someone to be heard. So
no doubt, no doubt. All right, y'all. So Allie, you're beautiful. You're brilliant. I'm the luckiest guy in the world. I'm glad that I get to share your brain with everybody. I hope you all know. I think she's the baddest lawyer on the planet. And we're going to be doing these YouTubes all the time. I know there's other lawyers out there, but I'll put my wife up against any of them. So in terms of knowledge and kicking it, she's like a human walking law book. So we love you guys. Thank you so much to everybody that became
thank you to all the new members and people who did the super stickers, and Carly and Dara and Jen and Deja Vu and Thierry and Debbie Share and MJ and Dizzy. Thank you all. Love you guys.
Jedi Platypus too. We love you guys so much. And share, subscribe, listen to the podcast, Defense Diaries. It's available anywhere. We're doing this to get you all to listen to the podcast. If you like what you hear here, you're going to hear even more, even better, because it's been produced by Darren. So it's tight, no flubs, no ums, no ahs, no breathing, no glitching. It's and they're great stories. We're telling stories, we're explaining the law, and we stick the law in there so that we do the same thing in the pod. We highly recommend that you listen to it.
And Publicly Buzz tonight, 10 p.m.
I was going to end with that because tonight's going to be a thing. Publicly Buzzed is going to be fire tonight. We got Chris Duet, who unequivocally has talked to more convicted murderers than any human being on the planet, serial killer, everything. The guy is unbelievable. And when I say spoken, I'm not talking like pen pal stuff. I'm like, this guy talks to these guys. So he's going to be incredible. And he's going to grill me, man. He's going to be getting all the Gacy knowledge that I have. And if you don't know, I did my first season on Gacy. My dad was Gacy's lawyer. So I've got some inside dope on that. My dad gave me the tapes. It's going to be a fascinating conversation. I guarantee it. It's going to be amazing content. So if y'all are hanging around at 10 Eastern, 9 Central, come and join us. You'll love it. I guarantee it. And I think that'll wrap it, girl.
Yes. And also, if you like this kind of court stuff, you've got to check out The Shaming of Jay and his wife, Shannon. Amazing pair. Or if you like husband-wife pairs,
they're another one.
They're another one.
Yep. My brother from another mother, Jay. Shaming Jay, his channel's on fire. He's probably going right now. I went longer because I never want to butt up against Jay because they're my boys, and the same with Steve and Dan. I never want to butt up against them. I gave them forewarning. I'm like, yo, I'm going to be doing this. So they knew I thought it might only go an hour, but with my big mouth,
and mine,
it's always going to go longer. So, all right, y'all, we're going to end it there. We love you so much. Thank you for hanging with us. And we'll see you on the next stream. Monday, probably. I think every Monday and Wednesday we're going to be going, but sometimes if something pops up, different times too. All right. Yo, just facts. Peace.